Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
Know your lane for what you saying, yo. Silly with my 9 milli with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While up in the club, I be wild in the studio. You don't wanna violate, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. Like a nigga that'll slap me with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, look at shorty, she a little cutie, yo. The way you shake it, make me wanna get all in the booty, yo. You would know your lane for what you saying, yo.
Diva Divine Light.
Really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you.
Here comes the pitch, and it comes in wide. Another combo.
Yo, hello everyone. What's up? What's up? What's up? What's up, everybody? How's everybody doing? Y'all ready for the music battle later? Are y'all ready? I think I'm ready. I don't know. I think Black Girl Beauty's gonna give me a black eye. BG, she gonna give me a black eye. She gonna get me later. Pow, pow. What's up, everybody? Hello, my OCOB family. My loves in the building. Everybody in the bushes. Hello, family in the bushes. What's up, y'all? Hey, T-Bam. Hey, Missy. What's up, Vanetta? Hey, Les Smith. What's up, K-Love? She said, hey, everybody again. Les Smith says, hey, fam, the info in these motions reveal a lot about what R. Kelly did. Listen to what they're objecting to. Sounds like evidence they think the government has and are trying to refute beforehand. Well, that's exactly what's going on. They're trying to get rid of evidence. They don't want certain things submitted. And they want certain things taken out. They don't want certain things added in. That's what they have to do. They're trying to, get it so that there's not a lot of evidence pointing the fingers at R. Kelly. But according to the hearing, R. Kelly has evidence of his own that he wants to present in this case. The only problem is that in certain instances of evidence, like they were saying in the hearing, is that he doesn't have a proper alibi because he doesn't have the specific dates or something to that effect it was. Yeah, it was a lot in that hearing. Hey, Flawless. Hey, Jackie. What's up, ladies? Hey, Tay Weezy. What's up? Welcome, welcome. Hey, Sin. What's up, Beb Davis? What's up, lady? Hey, Diva in chat. So they took all but $500 of Prissy's money that the fan been sending. They took $500. What, from the defense fund? Yes, please hit that like button. Thank you. Hey, Tears, what's up, mama? Fans send more money to help the victims. If they send it directly to him, that would be good. Yeah. Hey, Kat, what's up, lady? Hey, Charisse. Hey, Latrice, what's up, baby? Daddy's girl, what's up, mama? Hey, Nanya, what's up, mamacita? Kayla, what's up, mamita? What's up, baby? True Strong Warrior, what's up, warrior? What's up? Okay. Who else is in the building here? Did I miss somebody? I went fast, so. Okay, Latrice K Love. Okay. Hey, Classy. What's up, mama? All right. Hey, Mom Life. What's up, baby? All right. I said hello to everyone that's in the building. So, I'm going to read what's going on as far as what happened with the hearing, because that's what this is about, the hearing. Okay. I'm in the docket. All right. So this was filed yesterday. Okay. And it is the notice of docket entry. And it was made yesterday, Wednesday, August 3rd, 2022. And this was done by the Honorable Harry D. Lennenweber. And he states that there was a video pretrial conference that was held. And for the reasons stated on the record, the government's motion to impanel a confidential jury 246 is granted. So they will have a confidential jury where the juries will submit their jury questionnaires. And as soon as they submit them and the judge goes over them, they rule who they're going to rule out and rule who they're going to rule in. And then they destroy the information right then and there. They have to throw it away. They can't keep those on file. They can't keep that on record. They have to destroy that piece of record. Okay? And it has to do with their information, like their address, their personal information. That stuff gets destroyed. Okay? Then it says that the court's ruling on the motions in limine, the dockets, the documents, the numbers 211, 221, 224, 227, and 231 that was filed in the Northern District of Illinois. It says that it can be found in the attached order. So the government's oral motion to conduct a remote examination of a witness is granted without objection. Now, they were saying that one of the witnesses is really sick. They're hospitalized and they can't make it, but they do want to still testify at the trial. So that person will be allowed to do a video conference from where he or she is at to the trial in Chicago. So they'll have that person on a big screen, while that person's in the hospital or at home recuperating at the time, to be there for the trial, to just in case if the government does want to use them to testify, that will be the way that they will do it with that one person. Okay. And neither parties objected over that. Everybody agreed. Okay. Then it says that the government shall file its response to Defendant Brown's motion to compel discovery, which was document 247, which was submitted on or before Friday, August 5th. Okay, so they will have to put that in. The government will have to put in their response by Friday. Okay, it could be by end of day. It could be midnight. Up until midnight, they have to submit their response to Defendant Brown's motion to compel discovery. All right. And then Brown may file a reply to the government's motion on or before Monday, August 8th. So they have over the weekend to reply to the government's response. Okay, if they object, they have until that day. Then it says that the government shall file its responses to Kelly's motions to introduce evidence under Rule 412. Those are documents 237. Also, Kelly's motion to compel for discovery, which is 242. That's the other document. And Kelly's motion to bar testimony from the government's sexual abuse expert, numbered, that's document 243. And all this has to be done on or before Monday. Okay? So I believe in the hearing, if I'm not mistaken, June Brown's lawyer, I don't remember if it was June Brown. Was it June Brown? No, not June Brown's. Was it June Brown's lawyer? Or was it? Whose lawyer was that? I think it was June Brown. I don't remember who was the guy. Yeah, it was June Brown's lawyer, right? Shoot, I don't remember. But one of the lawyers was saying, the defense team, one of the lawyers was stating that, I don't remember if it was Daryl or Mr. Brown's. I think it was Daryl McDavid. I'm not sure. Mr. Brown's was saying that something about the file is just okay to introduce evidence under Rule 4112. Oh, like I forgot my thought. Shit. It was a lot. And so that's what's going on with that. All right. So they have till Friday and then till Monday. Okay. Now, this is the actual rulings that went on in the hearing that the judge put down. Okay. Rulings on motions in limine. The USA motion. So the USA had put in a motion to protect the identities of certain victims, right? That motion is granted. The government requests that the victim witnesses and minor one's mother be permitted to use pseudonyms during their testimony. Like we, the public, us over here don't know who they are, but for other people who don't know who they are, they will remain anonymous. Okay? So minor one's mother wants to be used by the pseudonym of her first name only. And the victim witness or minors one, they'd want to be used their first names only. Okay? And the government requests that no one disclose the address, full names of their family members or exact place of employment of any of the victim witnesses, minor one's mother or individual D. And the defendant's response, Kelly does not object to the motion. So he didn't have any objection to hiding her, their information. That's fine. So the motion was granted there. The USA motion number 2 that was filed was the motion to preclude evidence of victim's sexual history. In other words, they can't go back and say, oh, well, I heard that this girl was having sex with this boy in 1925 and She can't tell me that she was a virgin. Yeah, no. She had sex with 5 other guys before she met me. Oh, she was a stripper, or she was an ex-hooker, or she was a sex worker of any sort, things like that. She's had STDs and things of that nature, and pelvic inflammatory here, and HPV over there, or constantly with yeast infections, things like this. We can't be talking about it. No. So the government requests that any inquiry or evidence related to the victim's sexual history be excluded. So we can't put that in there. Okay, that's what that means. It's got to go. We don't care about none of that. That shit is irrelevant to this case. Doesn't even matter. You're just trying to use that to bash a victim, and that's not what we do here. That's not what we do here. So the defendant responded, and Mr. Kelly states that he has no intention of introducing any evidence for the purpose of sexual predisposition, but states that victims' previous sexual behavior may be relevant to questions surrounding consensual sex acts with Kelly when the victims were not minors. Huh? What? Huh? What he say? Wait a minute. What he say, y'all? Now, I'm not looking at the chat, guys. My phone is charging. I can't see nobody. But this is what? ¿Y qué he dije? What? But he states, guys, listen to this, guys, that the victim's previous sexual behavior may be relevant, y'all, to being questioned. So on examination, it's relevant. So when Bonjean comes to cross-examine these girls, their previous sexual behavior is relevant and can be questioned surrounding the consensual sex acts with him when they were not minors. So that means, so he's going to cross-examine them and speak about consensual sex acts even when she was an adult. Really? So what do you, what wait a minute. So what kind of question are you going to ask this girl? Wait. What kind of question, guys? Hold up. What kind of a question, y'all, do you think Bonjean or one of those lawyers, Ashley or whoever might be in place, is going to ask RL when she's on the stand about her sexual encounters with Kelly when she was over the age of 18? What kind of question would be relevant to their sexual encounters? I'm just confused, guys. Help me out with this one, please. Let me wrap my brain around. I'm trying to figure it out. What kind of a question would Bonjean ask? Let me see. Did you like it? Now that you were 18 years old, did you still feel like you were being victimized, or did you like it? Is that something she would ask? Oh my God, please, God. What kind of question, guys? Help me out with this bullshit. Wow. So, breaking news according to Kayla Dos. Oh, snap. News outlets are reporting he owes $140,000 in court-ordered fines, including a $40,000 penalty for a fund for human trafficking victims. Ooh, snap. Well, I got an order from the Eastern District of New York here. I don't know if it was an order or another motion. I didn't get to read it or look at it. So maybe I will come back tomorrow and check that out with you guys. So I'll go over that tomorrow. Definitely. And we will see what's going on with that, because I believe that's what that's about. I think it's about the Eastern District of New York restitution and fees and things like that now he has to pay. Yeah, we need like 20 people to tap in. Hey, Black Diamond. Hey, Eugenia. What's up, mama? Hey, Diva Time. What's up, baby? What's up, Diva? Hey, Candy. Let's see. Black Diamond. What's up, lady? Gone. What's up, Poppy? I see you looking all fly on Tia's page and shit. Yeah. That's how we do it. That's how we do it. Yeah. Of course, if they of age, they can't consent. Right. So, excuse me, guys. He wants to speak about that. You know, he wants to question them about that. Let me see what you guys say, and then I'll go back to reading. Lord have mercy. That's the order they took. That's the order they took, $27,000. Hey, baby, God bless you. I'm glad you're healing, Black Diamond. Amen, sweetheart. Amen. Thank God you're good, sweetie. My mom's about to go for surgery in her knee. Yeah. How you feeling? Bloomberg? Okay. I'm going to see if I find something on it too, okay? All right, so let me go back to just reading this real quick. Thank you, Les Smith. Thank you, Mama. You're welcome, baby. Hi, Mama. So, let's see. Let me go back to the document. Okay. So, that is so retarded. I can't. So, Kelly also objects to the exclusion of evidence regarding sexual contact of witnesses who were not victims identified in the indictment. So, the ruling is the motion is granted. So the government's motion to preclude evidence of victim about her history, they can't, the defense cannot, the defense can't say shit, period. For the USA motion number 3, which was motion to bar evidence and argument related to the consent. Now, the government requests that the court prohibit defendants from introducing evidence and arguing that the minor victim consented to engage in sexual activity while minors. Is he for real? What? Why would he want to do what? The government argues that minors lack the capacity to consent. Hello? Why would you argue that you want to introduce evidence that the minor at the time consented to engaging in sexual activity? It doesn't matter if she said, "Daddy, come suck me right now." It does not matter if she told you that and she was 15. You already screwed with her. You already got her whipped. And she's a minor. Minors are not allowed by law to consent to any type of sexual anything. No kissing, no touching, no sucking, no fucking. Period. I don't care if the girl called you 10,000 times in 3 hours and begged you for it and sent you pictures. You were supposed to go, "No, mamita, what are you talking about? Bye, lose my number. What? Why do you even have my number?" Good question. Come on, man. And the defendant responded to this by saying, Kelly does not intend to argue that minors are able to consent. However, Kelly argues that he should be allowed to cross-examine the minors about their conduct to negate inducement. Oh, stop! I can't. Come here, R. Kelly. Come here, baby. I just want to rub your bald head. Come here, baby. I'm 16 and I'm in love with a superstar. And just I love you. Please, please, R. Kelly. Come sit on mama's lap. Kiss me all over. Please. I love you. I love you. No! No! I don't give a fuck what they did. Can't no minor seduce no grown ass man who's in his right mind. No man with integrity or morals is going to sit there and say, "Okay, come here. Here, $50. Let me put it in your mouth." What? She wanted it. I cannot. And the ruling on that, the motion is granted. Kelly may not argue that the minors consented to any sexual behavior with him. It doesn't matter if she said, "Pee on me, daddy." It doesn't matter. Point blank, period. USA's motion number 4. Motion to prevent the public display of child pornography videos during the trial. The government wants the court to prevent the publication of the pornography to the gallery, overflow room during the trial. And R. Kelly agrees to that motion, so the motion is granted. So therefore, I don't want to hear shit about anybody saying that they did not show no videos. Okay? because they're going to show the videos. The only thing is they will not show it to the public. Again, let me repeat this. They will not show the videos to the public. Okay? Do you understand the words that are coming out of my mouth? Please help me help you understand that. All right? All right. Okay. So, the motion was granted. The USA motion number 5. Motion to introduce evidence of the polygraph examinations. The government seeks to introduce evidence and testimony about polygraph examinations for reasons unrelated to the correctness of the results. So the government argues that this evidence is probative evidence of the conspiracy charged in the indictment. And then the defendant's response is, Kelly does not object to the fact that polygraphs were used by McDavid. Okay, so R. Kelly's admitting that Mr. McDavid hired the man to take polygraph tests. R. Kelly's admitting that. Okay. Also, but then again, he objects to the testimony about the questions and argues that the results of the polygraphs as unreliable and unduly prejudicial. Now, I have a question about that. So, R. Kelly, so you're telling me that the polygraphs don't work? Is this okay? Wait a minute. So you're telling me that you object to the testimony of the questions, the questions that were asked in the polygraph examination. You're objecting to that. And that you're arguing that the results of it, to those questions of this polygraph, was unreliable? Really? So, what made you think that? So when you did these polygraph examinations, did you not think you were going to get the truth or a lie? I'm confused. So why did you use them if, according to you, they're unreliable? I'm totally confused. So McDavid had the idea. So does McDavid agree with you that this was an unreliable source, a way of trying to find out the truth on who got what tapes and where and how and who? Huh? Well, I'm sorry, but according to the judge, he ruled that this motion was granted. So, sorry for you, buddy, but the motion to introduce the evidence of those examinations are coming in, and they're very much reliable, because if they're reliable for you to use them, then they're reliable enough for the government to use. I mean, yeah, no, I'm just saying. USA motion number 6. The notice regarding introduction of the false records alleged in the superseding indictment. So, the government, as we all know, they want to admit a memo summarizing an interview of individual D, okay, to show that McDavid and Kelly conspired to obstruct justice. Now, the government alleges that the memo contains false information and is not privileged. So, now remember that the government has the memo that Lisa, right, made in the lawyer's office, changing her testimony, stating that it wasn't Rashonda on the tape with them or something like that. Remember, guys? Something of that effect, that it was that R. Kelly wasn't on the tape, or she wasn't on the tape, or it was a lie, she made a mistake or something. I forgot exactly what it was, but it was something to that effect in that memo, stating that it wasn't them on the tape. Okay. And remember, according to Lisa, she said that she had a meeting with them and she did a polygraph examination and all that and that, so that then when she went in to go see the lawyer, she had to change her statement from this to that, so that when the lawyers got on the stand to cross-examine her, they made her look like a streetwalker, liar, extortionist, and all this shit. That's why she cried when she cried on the stand, because she knew at the end of the day she was fucking wrong, and she was still protecting R. Kelly's stupid ass. Okay? Even though she was there to protect the little girl, in the end of the day, she wound up lying and protecting R. Kelly. And that's what happened. So now Lisa has to make up for all of this and tell her truth on the stand this time around. Because R. Kelly and his fucking goons was like, you know what? We should have killed your ass. You're lucky you're not dead, so you better do something. Fix this shit. And she did what she was told. And as we know, R. Kelly, of course, was going to object to this shit. And he said that the memo is not relevant evidence. What? What? Boy, sit down. Kelly also objects to the introduction of any police report. Wait a minute. You know, this is funny. This is a funny fucking statement right here that I'm about to read to y'all. Kelly also objects to the introduction of any police report that allegedly contains false statements of minor one. What? Why? Why, R. Kelly? Everybody's always saying, but where's the police reports? But where's the police reports? I want to see the police reports. God damn it. R. Kelly's innocent. Where's the police reports? Where are they? Here you go. And he doesn't want them to be shown. Why? He's innocent. According to the supporters, if R. Kelly shows, if the girls show police reports, then there really was a rape. Right? And in this police report, she was forced to lie and say that nothing happened. It's the opposite. Yes, bring in this police report. Please do. And guess what happened? The ruling on that was granted. Bring in the police reports, please. Thank you. USA motion number 7, government's notice of intent to admit direct evidence of crimes charged. The government intended to introduce testimony and evidence of the physical, emotional, and sexual abuse that Kelly inflicted on minors 1, 3, 4, 5, and 6. Testimony and evidence. Okay? And Mr. Kelly responded to this motion by saying that he objects to the introduction of any of this evidence that is not directly relevant to the crime charged, and any evidence that is barred by Rule 403. That is not hearsay evidence. The minors who were actually there is not hearsay evidence. It's factual evidence. It's direct evidence because it's coming from the horse's mouth, the person who was there. And there is evidence proving that these minors were physically, emotionally, and sexually abused. How are we not going to show evidence? We need this evidence to put your ass in jail. How are we going to exclude that? Are you kidding me? And guess what happened there? The ruling was granted. The motion was granted. But, there is a but. There is a but. So the government is allowed to admit the testimony and evidence of minors 1 through 6. Okay? But the defendants may raise objections during trial if they see fit. That's it. That's all. So if during the course of the trial, while they're being examined, if the defendant wants to say, object, he could do that. Okay? And I believe Judge Linenweber was also saying that if they object, they can cross-examine the witnesses right then and there, instead of doing it like Judge Donnelly did it. Day 1, the government does the direct of everybody, and then day 2 goes the defense and do the cross-examinations. He's not going to do it like that. He said he wants this trial to be quick, speedy, hurry up. He ain't got no time. He ain't got no time. Yes, he did say, I believe that in the hearing, I was listening to that call, and I believe at that point in time is when he said that. If not, it might be another part. I might be mistaken, but I believe that's what he said here. That when they object, when the defense objects, they can cross-examination right then and there and get it out of the way. Instead of one day here, one day there, one day here, one day there. He said that might just speed up the process. That's how he likes to do things in his court. He said that. I believe I was there. Yeah. Now, USA motion number 8. Motion for prior notice concerning the Rule 608B impeachment. So the government asks that the court bar all parties from introducing evidence under Rule 608B except upon prior notice. So outside the presence of the jury. So the government proposes that parties first notify the court and other parties at sidebar of its intent to impeach under the rule. And the defendant's response is that Mr. Brown argues that the government's request is unprecedented, and Brown notes that Rule 608 does not contain a notice provision. Now, Kelly also objects to this motion, and this motion was denied. So so they are allowed to introduce evidence under 608B. Let me see what 608B is real quick. Hold on, y'all. Let me do some quick research real quick and see what 608B is. Okay. So 608B is the Federal Rules of Evidence that provides one of the most useful and powerful impeachment tools available to lawyers during cross-examination. Specifically, Rule 608B, okay, it enables lawyers to ask targeted and damaging questions about a witness's past bad actions or specific instances of misconduct during cross-examination. All right, so in other words, he's allowing the lawyers during cross-examination to ask the witnesses about their past bad actions or specific instances of misconduct during cross-examination. Now, that makes no sense. Why would you grant this motion? Okay, no. So it's, but you're not letting in the, okay, so in other words, the government doesn't want them to allow evidence of the girls' past behaviors, but they will allow the defense or both or all parties to speak about the person's bad behavior at cross-examination. Wow. So, okay. So the government asks that the court bar all parties from introducing the evidence under the Rule 608B, okay, except upon prior notice, outside the presence of the jury. So the government proposes that the parties first notify the court and other parties at sidebar of its intent to impeach under the rule. So no, they're not going to be, they don't want to be notified by sidebars about this stuff. To you're gonna say right then and there, objection, Your Honor, and can I cross-examine him right here under the Rule 608 right now? Because I have a concern. This girl or this guy is lying because that's what happened. This is what happened, and that is what happened. Right? Is that what that understand? That's what I understand by that. That's what I get by that. I'm not a lawyer, guys. That's just what I'm thinking. I might be wrong. The USA motion number 9. Motion to preclude argument or evidence designed to elicit jury nullification. This motion is broken down into several subparts as seen below. Okay, so the first part of the illicit jury nullification In the argument, they're saying that the motion to preclude argument or evidence concerning potential penalties faced by defendants if they are convicted. So the government is asking that the court preclude defendants from introducing evidence or argument discussing the possible penalties or sentence should the defendant be convicted. The defendants had no objection to that. The motion was granted for that. So, motion to preclude allegation of outrageous government conduct. The government moves to exclude evidence or argument by counsel of outrageous government conduct. The defendants have no objection about that. The motion was granted. On the other part, Part C, motion to preclude argument and evidence regarding the government's motivation in investigation and prosecuting the case. The government moves to exclude any evidence or argument relating to any officers or agents' motivation for investigating or prosecuting the case. And then the defendant's response was no objection to that. And the motion is granted for that. Okay. And the motion to preclude argument and evidence of selective prosecution's theories. So the government moves to exclude any evidence or argument that some witnesses who participated in the conspiracy to receive child pornography were never charged. So the government also moves to exclude any evidence or argument that the parents of the victim witnesses should have known about the minor's sexual relationship with Kelly, and by saying nothing, consented to the relationship. Now, the defendant's response is that Mr. Brown argues that the government's request is impermissibly broad and that the evidence and argument regarding the parents of minor one are relevant. Now, Brown argues that Kelly's relationship with minor one's parents is relevant to Brown's belief that minor one was of age, or that Kelly's relationship with minor one was not sexual. Now, the ruling on that motion is that it's denied in part. So, Mr. Brown may argue that he believed that any victims were not minors. So Mr. Brown can say, well, you know, R. Kelly told me that she was 18. I didn't know she was 15. I didn't ask for her ID. I didn't go to her father and mother and say, hey, by the way, is she 15 years old? I didn't do that, so I don't know. I thought she was 18. I thought she was 17. I didn't know she was 13, 14, 15, 16. Nope, not me. Nope, no, sir. He lied to me and he said she was 18. Interesting. So, Mr. Brown, you cannot go in there and say that I did not know that she was a minor. You can't, because you went and made hotel reservations for a minor because you knew she was a minor, and R. Kelly said, well, you have to book the hotel for her because she can't because she's 16. So you need to go and book that hotel for her. Thank you very much. And what happened to you? Why? Why'd you fall? Why are you falling anywhere? Why are you falling anywhere? Okay. Then, in the second part to that, the motion is granted, okay, as to exclusion of evidence that minors or their parents consented to a sexual relationship with Kelly.
Nice. Grab your load on that. Do what I do. Grab it, shoot them.
So,
grab it, shoot them, kill them. If I get on, we're doing it. Young. This map sucks.
So the motion is denied to where they can argue that they didn't believe that the girls were victims, but the motion was granted to exclude the evidence that minors of the parents consented to a sexual relationship with R. Kelly. So they can exclude this evidence that the parents consented to a sexual relationship to R. Kelly. Now, the next motion, number 10, was a motion to exclude discovery requests or commentary regarding the discovery in the presence of the jury. So the government asked that the court preclude the parties from requesting discovery or otherwise commenting on discovery matters in the presence of the jury. And R. Kelly does not intend to have discovery disputes in front of the jury. So this motion is denied as mute. There's no sense in this dumb shit the government did. It's stupid. Throw it out. We're not even paying attention to none of that shit. Denied. Then motion number 11 is to exclude evidence of arguments regarding the constitutionality of the statutes criminalizing the production and receipt of child pornography. So the government alleges that arguments which pertain to the constitutionality of the statutes criminalizing child pornography offenses are wholly irrelevant to the indictment in this case. Can you give me my bar? Give me my Kit Kat. And then, yeah, David's all in my microphone chewing on his onion rings. I apologize, guys. Defendant's response, Kelly had no objection to this. So the motion was granted on that. No, I said the Kit Kat. I don't want the Snickers. I want the Kit Kat. Now, motion number 12, motion to preclude argument or evidence of non-pertinent traits of defendant's character. The government moves to exclude defendants from presenting evidence of their lawfulness except by reputation or opinion evidence. And Mr. Brown responded to that, and he argued that he may present testimony of his character of being a law-abiding citizen through specific instances of conduct, and Kelly intends to abide by the rules of evidence and does not intend to affirmatively introduce evidence of good character. So R. Kelly is not going to introduce any good character of his. He don't give a shit. Brown wants to say, oh my God, I pay my taxes. I vote every year. You know, I have a good driver's license. I graduated high school. I went to college. You know. So the ruling on that motion is granted. So the defendants may introduce evidence of being law-abiding, but only through reputation or opinion testimony, not through specific instances of conduct in line with Rule 405. The USA motion number 13, motion to preclude defenses of alibi or unavailability and mental defect. Now, this is where R. Kelly was arguing and saying some shit at the hearing. Babe, you didn't bring my Kit Kat. The government moves to exclude any evidence or argument. Can you bring my Tic Tac? I mean, my Kit Kat?
No, sorry.
Thank you. It's over there on the counter. And can you please pour me some juice, baby?
Thank you.
Thank you,
I'll
honey.
take the Kit Kat.
No, my Kit Kat, thank you. I got you all your snacks. This is all I have. Sorry, guys. Who's crying? I know you ain't talking to me, boy. Wow, this shit is melted. That's for sure.
I wonder what, because it's 90 degrees inside.
Actually, it's 82. Now,
Oh, Mom, you're gonna have some hot iced tea. The ice ain't ready.
there's no. That's all right. I don't care. Just give me something to drink.
I'll put ice in it. Even though the ice is still
No,
water.
no, David. Now, the USA motion number 13, motion to preclude defenses of an alibi or unavailability and mental mental defect. Thank you, baby.
Who's a mental defect?
R. Kelly has one.
I think he's just a defect.
What?
I said I think he's just a defect.
Yeah.
He's a defect to this world. Oh!
Lord have mercy. My son said R. Kelly is a defect to the world.
He just got roasted!
Oh my God.
How many years has he been touching little girls for?
Over 30 years.
Oh, okay. He's been a defect to this world for over 30 years then.
Mm.
Ah!
Okay. All right, let me get back to my stuff. Thank you. All right, so the government moves to exclude any evidence or argument relating to alibi or mental defect because defendants did not provide the adequate notice prior to trial. So you can't come and be like, listen, I'm mentally retarded. That's why, while you're in the middle of the trial, you were supposed to talk about all of that before that. So they want to exclude any evidence or arguments relating to alibis or mental defects. You know, like saying, oh my God, R. Kelly has a sickness. He, due to his trauma, mentally, he can't capacitate. He ain't know what he was doing. Temporarily insane. So R. Kelly argues that he can't provide any alibi at this time due to the indictment's allegations and that the offenses span 20 plus years. So he ain't got no evidence of no damn alibi where he was, what time and date, and none of that. He know what he did when he did it, though. He was there. And now the ruling on this motion is granted. According to the Rule 12.1 and 12.2 of the Federal Rules of Criminal Procedure, the defendant must provide advance written notice of any potential alibi or insanity defense. So if you were going to do it, now is the time to do it, not later on during the trial. Okay. Motion number 14. Motion to preclude defense counsel from defining the term reasonable doubt. What? Motion to preclude the defense counsel from defining the term reasonable doubt. Really? So the government argues that it is improper for attorneys to define the term reasonable doubt. And the defendant responded with none at all. And the motion for this is granted. So you can't go around in court at trial talking about que you can. But, and you got to put it in your mind that there was reasonable doubt that you can't use those words. Scratch that. We're not allowed to do this. Can't do it. And the motion was granted. So, no, we're not doing it. Not happening. Motion 15. The USA's motion number 15, which was motion to allow government to recall the case agent during its case in chief. So the government asked permission to recall the case agent during trial. So the government proposes that after every direct examination of the case agent, the defendants can cross-examine the case agents. Okay, so this is what they were talking about with the crisscrossing and all of that. That I was confused. I was like, what is he talking about? I was lost for a minute. So the government is asking permission to recall the case agent during the trial, and that after every direct examination of the case agent, the defendant can cross-examine the case agent. Okay, so it's to make the trial speedy, like he was saying. Now, R. Kelly wound up arguing that the court should use its discretion and not allow the government to recall the case agent too many times. Now, the ruling of that is the judge granted the motion. However, the court may use its discretion to prevent the government from needlessly recalling the case agent. Okay. So, motion number 16. This Kit Kat was really good, guys. Motion to admit business records pursuant to federal rules of evidence 8036 and 90211. So the government is asking that the court admit the evidence listed in the government exhibit 1 under the business record exception. Now, R. Kelly responded, and he doesn't object, but he asks for reciprocity if he seeks to introduce similar evidence. So, in other words, if the government wants to admit this evidence, right, of these business records, R. Kelly wants to be able to debunk it with his own evidence of the same type of evidence. Okay? Okay. And the motion for that was granted. So they will be allowed to admit the evidence. And R. Kelly will be allowed to introduce evidence to debunk that. All right. Now, as to the government, the USA Santiago proffer, the government asked that the court admit specific categories of statements made by co-conspirators in furtherance of the alleged conspiracy into evidence pursuant to Rule 801D2E. So the motion provides an overview of the evidence that the government expects to be introduced, demonstrating the existence of a conspiracy. Now, the defendant responded, Mr. Brown and Mr. Kelly, they both allege that the Santiago proffer is insufficient because it does not identify which exact statements it wishes to introduce into evidence. Now, Brown alleges that the lack of specifics forecloses him from drafting necessary limiting instructions. Now, the judge ruled that this motion is granted. The Santiago proffer was granted. So, if the defendants believe that the government has not actually proved the existence of a conspiracy during trial, they may make a motion to strike or raise an appropriate objection. Okay? Now, Mr. Brown's motion number one, motion to permit Mr. Brown to admit evidence of his own character. That motion, like I said, it was granted in part. Defendant Brown may only introduce testimony of his character in the form of reputation or opinion evidence. And should he do so, the government may refute the testimony on cross-examination using specific instances of conduct. So they could debunk his lies. You know, if he's, well, you know, you were an athlete in 1922, but here, you didn't do so good, honey. Yeah, no, things like that, right? Now, Brown's motion number two, which was the motion to preclude the government from eliciting testimony regarding certain other crimes, wrongs, and bad acts by Mr. Brown. This motion is broken down into several subparts as seen below. So, motion number two, part A, motion to exclude testimony regarding Mr. Brown making travel arrangements for minors 4 and 6. Now, Brown specifically seeks exclusion of testimony, of grand jury testimony from minors 4 and 6, detailing how Brown booked their hotel rooms as they were minors. Now, the government responded to this by saying that they argued that Mr. Brown, his travel arrangements constitute direct evidence of the offenses. Now, the ruling on this is this motion is denied in part. Now, the government may discuss Mr. Brown's travel arrangements as direct evidence that Kelly enticed minors into sexual activity. However, the government may not argue that because Brown made travel arrangements for specific minors, it was more likely that he knew different minors were depicted in certain videos. So the government can argue that he made the travel arrangements, but the government can't argue that he knew that the girls were minors in those specific videos. Now, Brown's motion number two, part B of it, the motion to exclude testimony from the individuals B and D, as we know to be Charles Freeman, or no, either Keith or Charles, one of those two, and Lisa. I forgot which one is which again. Regarding Brown's role in arranging abortions for Kelly's partners. Yes, I think it was Keith Merrill. Keith Merrill and Lisa Van Allen arranging abortions for Kelly's partners, that they knew about R. Kelly, about Mr. Brown's roles in arranging for the abortions. And Brown specifically seeks exclusion of those testimonies from individual D, stating that Brown took her to an abortion appointment and posed as her uncle, and testimony from individual B that Brown arranged abortions for minors on Kelly's behalf. Now, the government response to this was that the government stated that it does not intend to introduce any evidence on this topic in its case in chief. So, in other words, this situation isn't really the focus of the case. Now, the ruling on that, the judge's motion is he decided to deny and that it is mute. So we don't care about this. What you talking about? Que exclude? We're not excluding any testimony over here. That's not what happening. We need to know what happened. You arranged those things. But this is in mute in chief because they're not really going to discuss all of that. That's not part of what they're talking about. Anyway, move on. Next. Part C of Brown's motion says that it was a motion to exclude testimony from individual B regarding Brown's role in inviting Kelly concert attendees backstage. Now, Brown specifically seeks exclusion of testimony from individual B, suggesting that Kelly would instruct Brown to invite girls aged 16 to 20 backstage. So government's response is that the government does not anticipate that individual B will testify that Brown helped Kelly invite girls backstage. All right, again, this is not a racketeering case. They're all nervous thinking that they're going to use the same exact tactics that they did in New York. No, they're not. New York was New York. That was a whole nother situation. We're talking about obstruction of justice, and we're talking about child pornography and a conspiracy to collect all these things to hide your evidence so you can conspire to defraud the government. That's what this is about. It's not about who made the abortions, when they made the abortions, how many girls he led backstage. None of that. Now, the judge said this motion is denied as mute. So his motion is denied. He like, what are you worrying about it? Boy, bye. Now, motion number 3 from Brown was a motion to exclude the government expert testimony from unqualified witnesses. So Mr. Brown wanted to exclude government expert testimony. Mr. Brown argued that the testimony about child pornography generally and typically offender behavior must come from a qualified expert witness. They're trying to say that the witness is not, the expert is not qualified? What? So the government responded like, the government does not intend to introduce such evidence. What are you talking about? What are we talking about? And the judge ruled that this motion is denied as moot. It makes no sense. Goodbye. Meritless. Brown's motion number 4, which was the motion to preclude government witness from providing summaries or statements from interviewed witnesses for non-testifying individuals. Now, Brown moves to exclude any statements from non-testifying individuals that violates his protections under the Confrontation Clause. Now, the government's response to this was that the government states that it will not introduce testimonial evidence from non-testifying individuals. And the judge says this motion is denied as moot. Go on. Go sit down. They're not doing none of that. Why are you paranoid? You're talking about things that happen in New York. It's not happening over here. Calm down. Brown's motion number 5, docket number 213. Motion to preclude the government from making golden rule arguments to the jury and the defendants. Now, Brown argues that it would be improper for the government to ask the jury to put themselves in Brown's shoes. So the government says the government does not intend to make this type of argument to the jury. And the ruling on this is denied because it is mute. This shit makes no sense. You just wasted my time. You wasted ink with this golden rule. Get out of here. Kelly's motion number 1. Motion to exclude certain other bad acts. This motion is broken down into several subparts as seen below. So Kelly's motion to number 1, part A. The motion to exclude evidence related to R. Kelly's marriage and alleged sexual relationship with Aaliyah. Oh, and that's another thing. He couldn't even pronounce Aaliyah's name. He said Ayayela. He said, and about this motion to exclude evidence related to Kelly's marriage and alleged sexual relationship with Ayalela. And I was like, it's Aliyah. I died laughing. I was like, what the hell? He chopped that up real bad. So the defendant argues that he is not charged with any conduct stemming from this relationship. Thus, it is inadmissible. Now, the government, as we all know, responded to that, and the government states that it does not intend to introduce any evidence on this topic in its case in chief. So this is denied. We're not talking about that, Mr. Brown. It has nothing to do, Mr. Kelly. This has nothing to do with that. Don't worry about it. We're not going to talk about Aaliyah. So they will not be talking about Aaliyah in the Chicago trial. The government just said that they do not intend to introduce any evidence on this topic in its case in chief. So they're not even focusing on Aaliyah either. Now, the second part of Kelly's motion, number 1, part B to docket number 221, which was the motion to exclude uncharged allegations of women who claim that the defendant abused or mistreated them. Like what happened in New York, the uncharged bad acts, right? So he was asking to exclude that. Now, the defendant argued that uncharged allegations should be barred, and that the defendant asked that the government immediately disclose any such evidence if it intends to present it at trial. Now, the government responded, and they said, the government stated that it does not intend to call anyone not identified in the indictment to testify about Kelly's abuse. So they will not be adding any uncharged acts as witnesses, okay? The government states here that they are not going to put in any uncharged acts. So the government states that some of the minors who will testify may state that others were present during Kelly's abuse, which would be direct evidence of the allegations in the indictment. Now, the judge denied this. Okay? So in other words, even if the government does decide to add uncharged bad acts, they can if they wanted to. So as far as excluding the uncharged acts, that was denied. And the government did let everybody know that they do not intend on calling anyone that is not identified in the indictment. Okay? But they state that they will, the minors who do testify, they will be stating that others witnessed the things that went on with the abuse. And that is direct evidence of the allegation of the indictment. Okay? So R. Kelly's motion, part C to it, is that it was a motion to exclude evidence that Kelly impregnated any accusers and or facilitated their abortions. Now, Mr. Kelly argues that this information serves no legitimate evidentiary purpose, but the government says that the government states that it does not intend to introduce any evidence on this topic in its case in chief. So R. Kelly's motion to exclude the evidence that he impregnated anybody is denied. It's moot, doesn't matter. And the government stated that they don't intend to introduce any evidence on this topic in this case. That's not their chief complaints. That's not what they're going for. Now, Kelly's motion, Part D, states that it's to exclude evidence that Kelly infected any sexual partner with herpes. Now, Kelly argues that this information serves no legitimate evidentiary purpose. Again, but the government responded, and the government states that it does not intend to introduce any evidence on this topic in its case in chief. That's not their goal either. And the judge ruled that this motion was denied by R. Kelly. We're not going to exclude evidence because the government doesn't plan on bringing any of this evidence in. And then Kelly's motion number 1, Part E of that motion, is to exclude evidence that he was previously sued by accusers and or settled lawsuits brought by those accusers. So the defendant argues that such evidence should be barred to the extent it only goes to his bad character, right? So the government says that such evidence will not solely go to Kelly's bad character, but rather as direct evidence of some allegations in the indictment. And the ruling on that is that the motion for R. Kelly was denied. So they're not gonna exclude any evidence about that. And the government argues that they won't solely go on that, to make him look bad. That's not their direct, but they'd rather use direct evidence that is dealing with the allegations in the indictment. So R. Kelly's motion for that, to exclude that, was denied. Now, Part F of the docket number 221, which is what we're breaking down right here, is the motion to exclude video recordings of sexual acts that do not involve the charged conduct. So Kelly argues that other video recordings should be barred. And the government stated that it does not intend to introduce any evidence on this topic in its case in chief. So the motion to exclude the video recording is denied as moot. The government does not intend to introduce any evidence on this topic in its case in chief. Okay. Kelly's motion number 1, Part G, is that the motion to exclude Kelly's prior conviction. He wants to make sure that they don't put in his New York trial, right? That's why he kept asking all these questions and everything's being denied, because they're not doing the same thing like they did in New York. They're not. This is letting us know right here, they are not going to use New York tactics. They're going a totally different route. This is a totally different case. So the motion to exclude Kelly's prior conviction, Kelly asked that the government be precluded from introducing evidence of prior convictions, including his conviction in the Eastern District of New York. So the government's response is that the government argues that limited testimony about Kelly's prior convictions should be allowed if he testifies. So specifically Kelly's racketeering conviction. So the government is asking that, they're saying that limited testimony about R. Kelly's conviction should be allowed if he testifies. Now, the ruling on that is that the judge said that the motion for this to exclude R. Kelly's prior conviction is denied. As to Kelly's recent racketeering conviction, so they will be allowed to speak about his prior conviction. So, yeah. This case is going to bury him. Yes, it is. RL is enough to seal his fate. It sure is. That's basically what they're saying. Like, her mother, and this whole conspiracy is just enough. We don't need more. We have enough. We got enough. We got everything we need. We don't need no more. Okay, take. See you later, mama. Be safe while you're driving. And Black Diamond, see you later, mama. Relax and lay down, listen, enjoy, laugh a little, you know. Amos! What's up, baby Jackie? Diva time. Jackie says he couldn't come up with a alibi, right? A lie, a little lie. Hey, Julie. I'm gonna have to catch the replay. I'm watching my grandpuppy, and she is as rotten as my daughter. Oh, girl, enjoy. I hope to see you in the music battle in a little while, guys. Let me guess. He was on tour, or he was perfecting his basketball skills. Hey, Queen. What's up, mama? Hey, Rockin' with the Truth. What's up, baby? Rockin' fine, but we need to prep invoices so he can run some refunds. Those straight jackets and tranquilizer darts are still on standby. Y'all crazy. Hey, Queen. Hey, Shorty. What's up? He's not lying. He's not lying. Cancel the Kleenex and smelling sauce fun. Sounds like he can hook them up himself. Oh my God. Kelly is never getting out. The time is near. Yes, sir. I believe that. Yes, please like, share, and subscribe, guys. Thank you. Somebody get Miss Esquire on the line. Yeah, really. So he is allowing the defense to use the accuser's bad acts, but not the defendants. Nah, that has to be wrong. Right? It's something. I'm going to see if maybe Miss Esquire could help us out with this a little bit. Hey, Miss Married, what's up, baby? Lady E, what's up, mama? Okay, I have a drink in one hand and a blunt in the other. Need to eat before I start my exercise. Yes, music battle, guys. If he allegedly has approximately $28,000 on his books, he's all right. Local causes can use your spare change. Okay. Hey, Jade Stone. What's up, Jade? All right. Let's see what else you guys are saying up there. Porch Peepers, it's Yolu, but stop believing hosts that keep chasing a virtual. It's coming out Mr. Ed's mouth. Exactly, Noonie. Exactly. If people don't start reading for themselves, shaking my damn head. Word up. Supposedly one of his BM for 4-5 mil in the bank. Really? Who y'all talking about here? Thought he was broke or nah? Yeah, exactly. Stop lying. Voice your opinions respectfully and only regarding the topic at hand. No extra noise about anything either. Anything other than the reading of the motions. Exactly. Exactly. Reports say might have 25% of the alleged approximately $28,000 on his books taken. That only $7,000 to go toward the $140,000 in fines. He'd keep establishing $21K. Okay, let me see. Let me see what's going on here. While I'm looking up other stuff, let's just let me share this video with you guys that I found earlier today. And this is from Chicago, CBS Chicago. Okay, let me go on mute. I forgot I have to mute.
With a trial date less than 2 weeks away now, attorneys for one of R. Kelly's associates have filed a bizarre motion in court. They're claiming the former lead prosecutor used deceptive practices to communicate with the journalist and potential witness. CBS 2 investigator Megan Hickey joins us live now. Megan, you spoke with the journalist at the center of this.
Right, Joe, except Jim DeRogatis tells me that he has been given no indication that he'll be called as a witness in the federal trial that's currently slated to begin in Chicago on August 15th. DeRogatis tells me that there was nothing improper about his emails with the lead prosecutor.
Megan, I have never shared anything with anyone, prosecutors or defense attorneys or sources, that hasn't already been published.
Jim DeRogatis, who first made public the allegations against R. Kelly more than 2 decades ago, confirmed to me that Assistant United States Attorney Angel Krull, the former lead prosecutor on this case, emailed with him in April of 2019. According to court records, she called herself Demetrius Slovensky and created the email account with the username Pied Piper 312. That burner email was the center of a motion filed in federal court Wednesday by Daryl McDavid's attorneys. McDavid is singer R. Kelly's former business manager, charged with helping cover up Kelly's alleged crimes against young girls. The attorneys say it wasn't until this week that they were made aware of the communications. The motion calls DeRogatis a potential witness because of his direct involvement in the 2002 R. Kelly investigation.
I've gotten so many calls, texts, emails dating back to the anonymous fax that launched this story in November 2000.
The U.S. Attorney's Office tells me Krull left their office in 2020 and is no longer associated with this case. But McDavid's attorneys argue that the late release of the emails give the appearance of impropriety. DeRogatis doesn't believe the filing should have much of an impact.
I think it means anything. I think just like in 2008, the defense is trying to say there was this vast conspiracy against Robert S. Kelly. Robert Kelly's convicted because of what Robert Kelly did.
Now, our attempts to reach Krull were unsuccessful. A spokesperson for the U.S. Attorney's Office declined to comment at this time, saying that they'll be filing a written response with the court by the end of the week. In the newsroom, Megan Hickey, CBS 2 investigators. Joe and Erica.
Thank you, Megan.
Well, listen, like just the way it's all set up, like for example, you could end up beating your state case, right? And then the feds will pick it up.
Yeah.
And you got to do a trial all over it. Proffer agreements, right? You could go and admit to everything, to murders, drug dealing, extortion, whatever, and implicate a bunch of other people and then not be charged for what you're saying in the process. Police can get into an interrogation room with you and lie about what your co-defendants are saying in order to get a confession out of you. And that's considered perfectly legal.
Well, it's not.
No, it is legal. No, it is legal. A police could lie to you to get a confession, and if you confess, it just is what it is. It doesn't matter what they said beforehand. You see what I'm saying? This is all legal in the courts. You are at such a disadvantage when it comes to the legal system.
Well, then, to go back to, I wish, I don't wish anything. I wish kindness on everybody, and that's hard on anybody being caught up in a coup. I just, but my heart goes out to everybody involved with the R. Kelly situation. The girls who feel they were damaged, the parents who feel they were at this point, and him, because, having a bunch of women throw themselves and be in certain places was considered. That's what happens when you're in a rock star situation. That was a norm.
Yeah, but of age women.
You say that, but then
Of age.
I was watching everything and Almost Famous. I was watching Almost Famous, one of my favorite movies, and he goes, "It's all happening now." They were 16.
Yeah,
and when
but R. Kelly, even like, remember like his early, Bump and
Elvis
Ride.
Presley
So show
married-
me some ID before we get deep. Like
Elvis Presley was with his wife when she was 14.
Yeah, it was some real scumbag shit, and I agree. Like he should be, vilified for what he did.
Times have changed, and the image on what they do is why I smoke weed on my balcony. It's the reason I smoke weed on my balcony, and I'm only happy or I'm only going while I'm celebrated. I walk in the thing like, dog, I'm telling you, it gets to the
Miss Esquire, do you have time to hang out for a few minutes? Miss Esquire, you still in the building? Say what's up to Miss Esquire, everybody. You in here, baby? You in here, baby? You still in here, lady? All right, cool. I'm going to drop the link for you. Okay. Okay, real quick. Miss Esquire. All right.
Upstairs.
This Elvis thing is getting old. It really is. Listen, he got the girl at the age of 14. All right, she did admit that he was drugging her up and things like that, but that he never touched her in bed, which I technically believe is bullshit. I think he did touch her at a young age. I don't want to hear it. I believe he touched that little girl, but the parents did give him permission to marry her and to be with her. Like back in those days, it was a little different. Now we're not having that. Yeah, she needs like 15 minutes. That's fine. I'm gonna try to pin the let me see if I can pin it from here. If not, I gotta go to my phone. Let me see if I can pin it.
That's the one that kept getting me.
If I star it, will it? No, I think it just let me see. Did I pin the StreamYard? Did I pin the StreamYard to the chat, guys? I don't know if this star means I pinned it. Because it doesn't really say anything. Let me see. Did I pin it to the chat, guys? Hold on. All right, I pinned the StreamYard link. I went and I got my phone. My phone's at 70%, so I'm good for now.
Yo, somebody
Baby,
just
have a
closed the
hashtag
door.
over there?
Yo, how the fuck did he know I was there? Yeah, he opened the door and threw a grenade at me like he knew I was there.
All right, so, oh God, this Elvis thing. They're still doing with this Elvis thing. Okay, she needs, Elvis is dead. They need to stop. For real. All right, I got it. I pinned it now. I went over to my phone. Okay. Why do they keep going back in time to the 20s, 30s, 40s, and even still, it doesn't make it right? Exactly, it doesn't make it right. But back then, things were different. It is that. It really is. Okay, baby. Thank you, Mama. Julie, exactly. Also, she says they didn't have sex till marriage. Right. At 21 years of age. Plus, she lived with his family. Yeah, she lived with his family. His mom was there and stuff like that. Like, I mean, yes, they went to sleep in the bed. She said he never touched her, but I don't believe that. Like, how can you say you're in love with this little girl? She's 14. You bring her to your home. You move her in. She's living in your house. She's sleeping in your bed. I mean, you were giving her drugs to help her sleep. I mean, I don't know. It was very strange. I just found that relationship to be very, very strange. And I just don't condone that shit, period, anyway. You know what I mean? So, if anybody wants to come up for now, I pinned the link. You're welcome to join the panel. If anybody wants to come in and say something, you're more than welcome. I pinned the link in the chat, guys. Okay. Hey, SK, what's up, mamita? Candy, that's correct. She says she practically begged him on hands and knees for sex, but he kept her a virgin till wedding night. You know what? Yes, she did say that too. She did say that. But it's just so odd. I don't know what to believe. You know what I mean? Like, we weren't there, but I don't. But he was sleeping with a 19-year-old during the relationship. Yes, he was with an older woman, an older girl at that time. I believe she was in a couple of his movies, right? She wound up being in a couple of his movies. It was a girl that he hooked up with doing the movie set or some shit like that, right? Or doing his video or something. Or the movie set. It was a movie set, I believe. So... Let me take this off. Okay. Elvis sang better. You ain't nothing but a hound dog. My favorite was Jailhouse Rock. Oh, man, that's funny. So, guys, I'm getting ready to do this music battle. Let me see if I could get the well, let's finish listening to John Saley, who's a basketball player, speak about Elvis and R. Kelly.
Point now, if you see someone attractive and you were to say, man, you really look like that could be sexual harassment. Yeah. That's ridiculous to me. So you say nothing. It's like but then you're part of the problem. Like, I think about a lot of things before I'm going to answer you. It may not seem like it, but my brain is scrambling. Like, I'm on full court press for every question you got up in my brain. Right. But you get to a point where, some things were messed up and they should be done.
Hey, Black Girl Beauty!
Man, I'm with Dave Chappelle. Like, sometimes y'all got to get out of this. You're on this side, I'm not paying attention to you, whatever. Like, a Republican and Democrat, they're going back and forth. People are starting to realize they're the same people. So it's you're sitting around fighting on something that doesn't enhance you. And so if it doesn't enhance me, I don't do it. And I look at that with everything. And I'm glad that I didn't do really anything that can put my future in jeopardy. Like, I didn't tell on anybody. If I know something, I don't know nothing. I ain't seen nothing. I thought you were blind till you walked in here, officer. Like, I'm you know what? Don't ask me. Like, that's not how it's going. That's why, like, when they were saying, man, Vlad is a Fed, I go, for asking you a question of things he's seen on YouTube already, I said he just does research and he asks you about the things that he's read that you've already answered, so he kind of knows where you're going. I had to tell people that's how you did interviews.
Good evening and thanks for watching.
Now, I want you guys to check this out. This happened in February of 2018 in Bangkok County Courthouse. Okay, they had a confidential jury, and this is what went down.
Good evening and thanks for watching.
Hold on. Let me share this with y'all. Like I said, this happened back in 2018, and it was in Bangkok County Courthouse, and they failed to shred confidential jury information. Check it out. Let me go on mute.
Watching tonight, I'm Matt Davenport. Every day, we turn over personal information to companies, websites, and the government, and all we can do is trust that they'll take care of it. But recently, we found out public officials did not keep personal information private. KPVI, news that works for you, reporter Rachel Cox-Rosen discovered this breach of trust. She joins us now live from the Bannock County Courthouse to tell us what she found. Rachel.
Matt, the courthouse says they take concealing the public's private information very seriously. But as we discovered in this investigation, officials admit they made a mistake.
Oh, wow. Rachel Mayer is a 27-year-old graduate student at Idaho State University. I'm showing her a list found in a recycling bin behind the Bannock County Public Defender's Office. On it, her name and others with phone numbers, addresses, and more information. And she's not the only one.
It does have my employer, has my wife's job.
Scott Wood is a husband and father of two. His name is also on the list.
And their names weren't just on any list. They were on a juror roll call list, which they thought was confidential.
Rachel and Scott gave this information to the county through a jury summons questionnaire to serve as potential jurors in a case. Instead of being shredded, it was tossed out. Rachel says this is scary, especially as she's a young woman living alone.
With social media and everything, like there's a lot of information that's made public, but it's never my address. My phone number isn't out there. I control like who gets to see what. And with this, like all that, like control is really taken away.
What both Rachel and Scott want to know is, why wasn't this information shredded? Well, officials at the courthouse don't know how it happened.
Obviously, on this particular instance, something happened that was not supposed to have happened.
In Bannock County, a juror roll call list starts in the hands of the jury commissioner. It then passes to the presiding judge, who gives it both to the prosecution and the defense attorneys. Each office maintains they destroy the information once they're through with it. Court officials say this was an isolated incident, but also eye-opening.
We've got to do better. We've got to do better to make sure that we're ensuring that the confidential information that is provided to us by jurors, by prospective jurors, is kept confidential.
An Idaho Supreme Court rule prohibits this information from disclosure outside the court system. Those in violation can be sanctioned or found in contempt of court. Judge Brown thinks a possible fix is implementing a local version of this rule. Meanwhile, the county clerk has bought 4 new shredders, and the prosecutor got a new locked bin for their office. Because in the end, protecting people's information is not only the right thing to do, it's essential for the courthouse to do its job, seek justice, and find truth.
We also checked on the Bonneville and Bingham County courthouses. Neither of them have outdoor recycling bins. I spoke with a Bonneville County courthouse official. She tells me they keep all their confidential recycled materials in a secure, locked location. Reporting live at the Bannock County Courthouse, I am Rachel Cox-Rosen. Matt, back to you.
All right. Thank you very much, Rachel.
All right, guys. So can you believe that? In Idaho, in the courthouse, they forgot to shred up information and somebody found that shit in the trash. That's crazy. it's very important for this confidential jury to be confidential. They're supposed to shred up that information right away. After they're done, they're supposed to shred it up. That's what a confidential jury is about hiding the information from the public and shredding that information. Hey, Miss Esquire.
Hello.
Hi, Mama. How are you?
Girl, I'm tired. I had a long day.
Girl, listen, my husband just got over COVID and
oh my goodness.
But he was okay. He didn't really get sick like that. He just had a stuffy nose, runny nose, a little bit of achy, but not really that bad.
Oh, thank goodness.
Yeah, he had the shots. He got the shots. So, that's what protects you. But Miss Esquire, since you're here, lady, we got this information from Judge Lennon Weber. And there was a hearing for R. Kelly that happened on the 2nd. And yeah. And this was the judge's rulings. And he ruled on all the motions that were put in. And some of the motions here, wait, I'm gonna try to find it. Hold on. It was the government's motion, right? Which one was it? Wait. Okay, wait. Was it this one? It was the one that was in part of something. Wait, let me see. With the minors, right? Okay, check this out. In this motion here, right? The government's motion, they asked to bar evidence and argument related to consent, right? So the government here is requesting that the court prohibit defendants from introducing evidence and arguing that the minor victims consented to engaging in sexual activity while minors. Now, the government argues that minors lack the capacity to consent. So the defendant responds, and Kelly says that he does not intend to argue that minors are able to consent. However, Kelly argues that he should be allowed to cross-examine the minors about their conduct to negate inducement. Now, the ruling on this motion was granted, and Kelly may not argue that the minors consented to any sexual behavior with him. So the judge granted the motion to bar evidence that R. Kelly wants to argue, correct?
Someone would, of course, choose to call me now. Can you hear me?
Yes,
yeah, wonderful.
I hear you now.
Okay. So the argument is, and mind you, it's an argument that, quite frankly, should not have to be made. Because as we discuss all the time, a minor cannot consent.
Right.
So the mere fact that the government has to make this argument is pretty sad.
Right.
But I think they know what they are up against and they know what they're dealing with. Right. So they want it to be abundantly clear that that argument is inappropriate. And the court agrees with the government that you cannot argue. So R. Kelly cannot argue that any of these minors consented to being with him in an intimate way. Now, what his attorneys tried to do is they tried to say, oh, well, we don't intend on arguing that they consented, but we want to negate that they were induced in any way or coerced in any way. And it seems like even that argument didn't hold up.
Right. That's crazy. How are you? That sounded crazy. And then this one here, the USA put in a motion to introduce evidence of the polygraph examinations, right? But Mr. Kelly responded that he does not object to the fact that polygraphs were used, by McDavid, but Kelly objects to the testimony about the questions and argues that the results of the polygraphs as unreliable and unduly prejudicial, and the judge ruled that the government's motion was granted to introduce the evidence. Why is R. Kelly is admitting here that the polygraphs were done and it was McDavid's idea. But he's objecting to the testimony about the questions and argues that the polygraphs were unreliable. What?
So in general, polygraph examinations are usually not really permissible in court. That's kind of just been the precedent, which is why the government isn't saying that they're going to argue the results of the examination. Like, notice they very carefully crafted that. Right. They said, we just want to discuss, the circumstances surrounding the polygraph or whatever. Go back to it so I can point. Okay, right. So see, they specifically say we're not going to discuss whether or not the results of the polygraph are actually correct. They're saying they just want to use it as evidence of a conspiracy, which is possible, right? Because a polygraph doesn't have to necessarily be accurate for you to have been involved in some sort of conspiracy with someone else that led to the circumstances of you taking that polygraph, or that led to the circumstances of that person discussing the polygraph with you, or whatever, right? So the government is saying that. They're saying, listen, we just want to talk about the person having a polygraph and the circumstances that surround that. We're not saying that the polygraph is, accurate, because historically, polygraph results have not been admissible in court. And the reason is that there are allegedly some people who can beat polygraphs.
Right.
So because of that, they're not considered to be like the most reliable thing.
Right.
Now
my
Kelly,
thing is
go ahead.
I'm sorry. My thing is he used the polygraphs to find out if anybody made any copies of the tapes and all this and that. But yet you're saying at trial that they're not reliable, but yet you still had the idea to use them to figure out who was lying about what. Like, does that make sense to you?
I mean, it doesn't make any sense, but guess what? When they discuss the polygraphs, I'm sure all of that will come out and he will look extremely disingenuous. It will look really bad to try to argue against the accuracy of polygraphs when you were using them.
Right. Like, that is just the weirdest shit. I was like, what? Okay, no. And then over here, he wants to the motion regarding to introduce of the false records that were alleged in the superseding indictment, right? That the government intends to admit the memo summarizing an interview of one of the individuals to show that Mr. McDavid and Kelly conspired to obstruct justice, and that the government alleges that the memo contains false information and is not privileged. So the defendant, Kelly, objects to this, stating that the memo is not relevant evidence, and that Kelly also objects to the introduction of any police report that allegedly contains false statements of minor one. But the motion was granted for the government to introduce the false records. How is it that he just objected to that? Like, what? Why would? Please explain this to me.
This is interesting. So the government wants to admit a memo summarizing an interview of individual D to show that McDavid and Kelly conspired to obstruct justice.
Right.
Okay, that sounds feasible to me. Kelly objects, saying the memorandum is not relevant.
Right.
Kelly also objects to the introduction of any police report that allegedly contains false statements of minor one. That's very interesting. So if the allegation, which the allegation is this, by the way, but if the allegation is that Kelly obstructed justice by causing a minor to tell the police something that was false, then
Right.
of course the report that contains those false statements is relevant.
Right.
I mean, that's obvious, right? Because that's the report that you need to look at to decide, okay, well, did Kelly tell this minor to say these things that aren't true? And so for
Right.
him to object to the use of it, saying that it's falsified, is it's either nonsensical or he should just plead guilty then, because you're saying that the report is false. But I guess he's trying to argue that she lied on her own.
Right. That she did it on her own. That it's crazy. And then there's this one over here. This one. The government notice of intent to admit direct evidence of crimes charged, right? So the government intends to introduce testimony and evidence of physical, emotional, and sexual abuse that Kelly inflicted on minors 1, 3, 4, 5, and 6. Now, the defendant's response was that Kelly objected to the introduction of any evidence that is not directly relevant to the crime charged and any evidence that is barred by Rule 403. Now, the judge's rule that he granted the motion, okay, which was being allowed to, the government's allowed to admit direct evidence, right? But the defendants may raise objections during trial if they see fit. Now, what does that mean? Does that mean that they can cross-examine them?
So in other words, what they're saying here, which this is another one of those very interesting arguments.
Right.
So the government says we intend to admit direct evidence,
right,
of the abuse that occurred allegedly.
Right.
Defendant says they object to any evidence that is not directly related. What?
Right.
They specifically said they want to introduce direct evidence. So at this point, I think they're just trying to earn their check. They just wanted the billable hour. Because I mean, they literally said direct evidence. So that first statement doesn't make any sense. Now the statement about it being barred by Rule 403, we know that that's an argument they're going to make throughout this entire response.
Hearsay, right? The 403 is hearsay, right?
I don't believe so. I have to double check, but I believe 403 is the probative versus prejudicial, that balancing act. But let me double check that, because the numbers. Let me see. Or can you double check that really quick?
Yeah, I'm gonna double check it right now.
Yeah, I think it's the balancing of probative versus unduly prejudicial. But it could. I don't think that's the hearsay rule. I don't think so. But I could be wrong, because I sometimes get the.
Oh yeah, no, you're right, Mama. It's excluding relevant evidence for prejudice.
There you go. So yeah,
for prejudice.
Listen, kudos to me. I'm not that rusty. So yes. So Rule 403 is the balancing act.
Right, about confusion or waste of time.
Right. So what it is, as I said, it's a balancing act. So the evidence has to be more probative, meaning it has to be more useful than it is unduly prejudicial. So what that means, kind of, in layman's terms, is if you have a video of someone harming someone in some way, and the video is extremely traumatic to watch, then a defense attorney could argue, you know what, this video is more prejudicial than it is probative. Because when a jury sees this video and sees how awful it is, they're going to hate my client right away, right? And so at that point, perhaps stills of the video may be used, pictures may be used, as opposed to the actual video. So that's just an example of kind of how the court does the balancing act. But the question is this piece of evidence more probative, more useful than it is prejudicial?
Okay. Now, this one, motion number 8, which was the motion for prior notice concerning Rule 608B impeachment, right? The government is asking that the court bar all parties from introducing evidence under the Rule 608B, except upon prior notice outside the presence of the jury. Now, the government proposes that parties first notify the court and other parties at sidebar of its intent to impeach under the rule. Now, we just looked up 60B and I forgot what it was. Now, the defendant's response, Mr. Brown, argued that the government's request is unprecedented and that Brown notes that the Rule 608 does not contain a notice provision. Kelly also objects to this motion, and this motion was denied.
So,
yeah, explain this one.
It is correct that Rule 608B doesn't usually have any type of notice provision. Now, I think this was an interesting request because I can quite frankly see how it would benefit a witness or a victim or whomever, right, to have notice of a 608B kind of line of questioning or of evidence that has to do with 608B. So in this kind of case, you know, for example, with Kelly and these young ladies, it is possible that R. Kelly and his defense attorneys could find evidence that they believe. So the same way that the government can argue that R. Kelly has a pattern, right, is the same way that through 608B, Kelly's defense attorneys can argue that any of these alleged victims have a pattern. And they can do it through the vehicle of, oh, they have a pattern of having a certain relationship with him, or they have a pattern of having a certain type of relationship with men who are similarly situated. Like that's the two pathways they could go down.
Okay.
And that's why it makes sense for the government to want prior notice, right? Because if they're going to kind of go at your victim that way, it would be nice for you to know ahead of time. But R. Kelly's attorneys are correct. I've never heard of a notice provision being implemented, and the rule itself doesn't have a notice provision.
Okay. And this one here, motion number 9, says that it's a motion to preclude argument and evidence of selective prosecution theory. So the government moves to exclude any evidence or argument that some witnesses who participated in the conspiracy to receive pornography were never charged. Now, the government also moves to exclude any evidence or argument that the parents of the victim witnesses should have known about the minor's sexual relationship with Kelly, and by saying nothing, consented to the relationship. Now, in defense, Mr. Brown argues that the government's request is impermissibly broad and that evidence and arguments regarding the parents of minor 1 are relevant. Now, Brown argues that Kelly's relationship with minor 1's parents is relevant to Brown's belief that minor 1 was of age, or that Kelly's relationship with minor 1 was not sexual. Now, the ruling on this motion is denied in part, but Brown may argue that he believed any victims were not minors, and the motion is granted as to exclusion of evidence that minors or their parents consented to sexual relationship with Kelly.
So the court said what we've been saying all along, Diva. If R. Kelly is trying to argue that he did not know that a certain girl was underage, then sure, he can make that argument. And if he has to bring up her parents to make that argument, sure, right? But he cannot argue that her parents consented to him having a romantic relationship with her. Why? Because people cannot consent to you committing a crime. One more time, because me and Diva have said this a million times. No one can consent to you doing something illegal. So even if someone says to you, go ahead and burglarize my home, doesn't mean you can do it.
Right.
So that's why he cannot make that argument, because they do not want him to try to argue that, oh, the parents gave quote unquote consent. That's totally irrelevant.
So the part that it says the motion granted as to exclusion of evidence that minors. So what? Wait. So the motion is granted to exclude evidence that the minors or the parents could say, okay, all right. So they're taking that out. That's
right.
Not even coming
so
in.
He cannot do that. So it's granted in that to that extent, but it's denied as far as he can discuss the parents if he's using that discussion as a part of his argument of his belief that they were not underage.
Okay. Now, this other part of a motion was to exclude discovery requests or commentary regarding discovery in the presence of the jury. So the government asks that the court preclude parties from requesting discovery or otherwise commenting on discovery matters in the presence of the jury. So this motion is denied as mute. And Mr.
So
Kelly
it was denied as moot?
Moot.
No,
yep.
go ahead. It was denied as moot. So when the court says something is moot, it just means it's not applicable because it's not an issue.
Right,
so,
it's just meritless. It has no use.
Right. So the government was saying, hey, we don't want to argue about discovery matters in front of the jury, which makes sense. Because
right, it makes sense.
That is actually how a jury could end up hearing something they're not supposed to know about.
Right.
If you're arguing about it.
Right, it makes sense. Right.
Right. But then R. Kelly's attorneys say that they're not going to do that. So, okay.
Right.
Now, here's the thing, though. If they do it, they're going to be in deep trouble because they have explicitly stated that they're not going to do that.
Right. Okay. What was the other one?
This water is salty.
Okay, this one here kind of had me a little, but I kind of understood it, but it was the motion to allow government to recall the case agent during its case in chief. So the government asks permission to recall the case agent during the trial. Now the government proposes that after every direct exam of the case agent, the defendants can cross-examine the case agent. Now, during the hearing, the judge was like, this seems pretty good, a good idea, because it will speed up the process of the case. Now, Mr. Kelly argued that the court should use its discretion and not allow the government to recall the case agent too many times. So the motion for this was granted. However, the court may use its discretion to prevent the government from needlessly recalling the case agent. Now, did I understand that right?
You sure did. They want to call the case agent multiple times, probably because they have so many witnesses, so many alleged victims, that one large testimony, Mac, here goes Mac. Here goes Mac.
We love you.
And he's going to be
you, Papi.
worse today because I have family over. Hold on a second.
Okay.
Okay, finally calmed him. Oh my goodness. Finally calmed him down. So, right. So they're saying they want to call the case agent multiple times because imagine one long direct examination, one long questioning of this agent in which he's trying to kind of establish the timeline and for every alleged victim. That would just be ridiculous. So it makes sense to call him more than once. Now, what R. Kelly's attorneys are saying is like, okay, they're saying, yes, but the court should use his or her discretion. They always do that. So
okay. And now, as far as the Santiago proffer from the USA, we know that the government is asking the court to admit specific categories of statements made by the co-conspirators, alleging to the conspiracy into evidence pursuant to the Rule 801, and that the motion provides an overview of the evidence that the government expect to be introduced demonstrating the existence of a conspiracy. Now, the defendants, Mr. Brown and Mr. Kelly, allege that the Santiago proffer is insufficient because it does not identify which exact statements it wishes to introduce into evidence. Now, Brown alleges that the lack of specifics forecloses him from drafting necessary limiting instructions. Now, the ruling on this is that the motion was granted, so the Santiago proffer was granted. But it says that if defendants believe that the government has not actually proved the existence of a conspiracy during trial, they may make a motion to strike or raise an appropriate objection. So during the trial, they could say, oh, motion to strike, right?
Right. So during trial, they could object. Or, as the judge is saying, they could impose an appropriate motion in which they argue that certain evidence should be stricken from the record, or that the jury should be given a certain instruction, not to listen to, or to limit. I'm laughing at Mac. So my cousin, who he just barked at as she walked through the door, he's now laid out on the ground, making her pet him. This is the person that he was just barking at.
Well, I'm sorry. I don't want to take up any more of your time. I got to get out of here too, because I'm about to start the music battle. But this would be nice if I can send you this email over to you, and maybe you can go over it on your channel, the whole thing, and break it down if you want to. Yeah?
Yeah, feel free to go ahead and send it.
All right, sis. I'm going to send it to you so you can really break it down on your channel, and we'll go visit you when you do. You already know. OCOV is in the building. We're here for you, sis. So thank you for stopping by. And thank you, Mama Yes, for always giving us your legalese insight. We love you, baby.
All right. Love you too. Bye-bye.
All right, Mama. Bye. Okay, guys. So that was great. Next time, we're going to check the rest of this out on Miss Esquire's channel. I'm going to send it over to her. Hopefully, she'll set up a live. When she does set up this live, I will share it with you guys. All right. I am going to end this live because we are going to get ready for this music battle, guys, on Miss Love Zone's channel. Can somebody please do me a favor and put Atmos's ¿cómo se dice? Atmos's his channel link up in the chat, guys, please. Thank you very much. And for you guys who have been donating to the transcript fund, thank you so much. We are at $450 so far. We're doing good. Keep it rolling, guys. We have day 1 so far, working on day 2 now. All right. We know that this trial is supposed to last for about 4 to 6 weeks, just like New York. It's supposed to last 4 to 6 weeks, just like New York. So, y'all, do me a favor. Y'all already know, if you guys are going to donate, please put in the for portion that this is for the transcripts. If you guys want to support the channel, help me out with paying the rest of my my Pacer bill. It was $311. I need $100 more. I'm not even going to front. I'm a little caught up right now. So if you guys can help me out with paying that bill, that would be great. My Cash App is Diva Divine Light. If you're going to send for the transcripts, please put 4 transcripts. And if you're sending it for me, say this is for you. Okay? So I can separate the money and put the transcripts money in my savings account, and, my money stays in my check-in. And guys, I'm going to take y'all out with this. Hold on. Thank you for the super chat, SK. I love you, mama. Hold on. I'm going to take y'all out with this.
I'm trying to have a relationship with my kids, and I can't do it. Y'all just don't want to believe the truth. You don't want to believe it.
At this point, we briefly pause the interview to give Kelly a moment.
Yo, let me with this. Yo, let me with this. Yo, let me with this. Yo, let me. Y'all gotta kill me. Yo, let me with this. 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 Let me get. Gotta kill me. Gotta kill me. Y'all wanna believe it? Gotta kill me. I'm about music. I'm trying to have a relationship with my kids, and I can't do it. Y'all just don't want to believe the truth. You don't want to believe it.
At this point, we briefly pause the interview to give Kelly a moment.